You are listening to Crazy Karen HOA. I was shoveling, and she was screaming. Karen stood beside my car with the tow driver and screamed that I was parked in a winter emergency zone and the hook was going on unless I moved it immediately. I am timing you, and the longer you stall, the bigger the fee gets. I looked at her, then at the tow driver, then at the curb where my sedan sat in a 2-foot drift of compacted slush, and I said, "Show me the zone." She held up a laminated sheet with a red border and jabbed her finger at a paragraph I could not read from 10 feet away in the gray January light. The driver hesitated, glancing between us, the hook swinging slightly in the wind. I work a FedEx-style route out of the Pleasanton Depot, which means I cannot afford tow delays. And she knew it. Laura Young, Fines and Enforcement Coordinator for the Meadows Property Owners Association, had been timing my arrivals for weeks, always catching me when I was already late or had to pick up my sister before the roads turned to glass. She wore a gray parka with the hood up over a red knit beanie, and a lanyard with a blank HOA badge hung around her neck like a law enforcement credential. I had a salt scoop in one hand and a small bucket in the other, because I had just finished spreading ice melt on my front steps when I heard the diesel rumble of the flatbed pulling up. She said, "You have 5 minutes before this becomes a lien on your property." The tow driver, a guy in a neon vest and a Carhartt jacket, looked uncomfortable. He said, "Ma'am, I need to see the ordinance number and the posted signage before I hook anything." Laura's face went red. She said, "I do not need to show you anything. I am the coordinator, and this is an authorized tow under association emergency powers." I said, "There is no signage. There is no ordinance, and you know it." She turned the radio on her belt to full speaker volume and keyed the mic. She said, "This is Laura. I need backup at Unit 217. We have a compliance refusal in progress." Nobody answered. The radio hissed static. She tried again. Still nothing. The tow driver said, "Look, if there is no sign and no written directive, I cannot just hook a car because someone called." Laura's voice went up an octave. She said, "Keep arguing. You are making my case for me." I felt a cold spike of recognition, because that phrase would come back later in a way she did not expect. She stuffed the laminated sheet back into her parka pocket and said, "Fine, you can move it now, or you can explain it to the hearing panel next week when they add obstruction to the violation." I said, "What violation?" She pointed at the bucket in my hand. She said, "That ice melt salt, you left it by your front steps in open storage, which violates curb appeal standards under Section 9 of the handbook." I stared at her. The bucket was a small plastic pail, the kind you buy at a hardware store for $3. I said, "It is ice melt for the steps so nobody slips." She said, "I do not care what the weather did, I care what the rule says." The tow driver started reeling in his hook. He said, "I am going to need a work order with a signature and a posted notice, or I am leaving." Laura's jaw clenched. She said, "You will hear from my attorney," and she turned and walked toward her white SUV parked 2 spaces down, boots crunching on the frozen slush. The driver gave me a tired look. He said, "Sorry man, she calls us twice a week, half the time it is nothing." He climbed back into the cab, and the flatbed rumbled away, leaving me standing beside my car with a salt scoop and a sinking feeling that this was just the beginning. I had bought the house in Pleasanton 6 months earlier because I needed to be closer to the depot, and my sister lived 20 minutes away in Livermore. The Meadows Property Owners Association had seemed quiet at first, just another subdivision with decorative streetlights and rules about trash cans. Then winter hit, and Laura discovered that snow and ice enforcement was an opportunity to turn normal life into a compliance battlefield. I moved my car into the garage and checked the mailbox. Inside was a yellow envelope with a violation notice dated that morning. The notice said I had failed to clear snow from the curb within 12 hours of the storm ending, and the fine was $250, due in 10 days. The storm had ended at 3 in the morning. I had cleared the driveway and steps by 7, but the curb was buried under a plow ridge that would take an excavator to move. I grabbed my phone and called the management company listed on the notice. A recorded message said the office was closed for the holiday weekend and would reopen Tuesday. I needed to pick up my sister in 2 hours, and the forecast said freezing rain after dark. I could not afford to get stuck in another confrontation, and I could not afford the fine either, because I was trying to sell the house and move closer to family before spring. Any lien or disclosure would kill the sale. I sat in the car with the heater running and stared at the violation letter, and I smiled, because it proved exactly what I suspected. Laura was not enforcing real rules. She was inventing violations on the fly and hoping nobody would check the actual handbook. I pulled the handbook out of the glove box, a thin stapled booklet I had received at closing. Section 9 covered exterior storage, but it only mentioned trash cans, grills, and recreational equipment. Nothing about ice melt. The snow removal section said homeowners were responsible for sidewalks and driveways, but it did not mention curbs, and it did not specify a 12-hour deadline. I took photos of both pages and saved them to a folder on my phone. Then I called my friend Aaron, a notary who helped me organize sworn statements when I had dealt with a landlord dispute a few years back. He answered on the second ring. I said, "I need you to witness something, and it is going to get weird." Aaron met me at a coffee shop near the freeway. I showed him the notice and the handbook. He whistled. He said, "This is textbook harassment. You need to document everything and file a complaint with the state." I said, "I do not have time for that. I need to stop this now before they put a lien on the property." He said, "Then you need leverage, something that proves they are acting outside their authority." I told him about the tow truck, the fake zone, the radio call that went nowhere. He said, "Do you have any of that on video?" I shook my head. He said, "Start recording everything and get copies of the meeting minutes, because if they are making up rules, it will show in the records." I left the coffee shop and drove to my sister's place in Livermore. The roads were already slick and the temperature was dropping fast. She climbed into the passenger seat with a worried look. She said, "You look like you are about to fight someone." I said, "I might be." She asked what happened, and I gave her the short version. She said, "Can they really do that?" I said no, but they are betting I will not call them on it. She pulled out her phone and started searching HOA law in California. 10 minutes later, she said, "They need a quorum vote to impose a fine, and they have to give you notice and a hearing." I said there was no hearing. She said, "Then the fine is not valid." That night I went through every email and letter I had received from the HOA since I moved in. There were 3 prior notices, all minor, all paid without argument. One was for a trash can left out past noon on collection day. Another was for a porch light that burned out and stayed dark for 2 weeks. The third was for parking my work van in the driveway overnight, which violated a commercial vehicle restriction I had not known existed. I had paid all 3 fines within the 10-day window, assuming they were legitimate. Now I wondered how many of them had been real. The next morning I woke to another yellow envelope in the mailbox. This one was a second notice for the curb snow violation, with an added fee of $50 for non-response. I had not even hit the 10-day deadline yet. I called the management company again and got the same recording. I left a message with my name and address and said I was disputing the fines and requesting a hearing. Then I called Aaron and told him I needed him to come to my house with a notary stamp and a witness statement form. He said he would be there in an hour. While I waited, I shoveled the driveway again, even though it did not need it, just to have something to do with my hands. A couple across the street stood on their porch watching like it was a show, the husband holding a coffee mug and the wife pointing at the snowbank by my curb. I waved. They did not wave back. That was the kind of neighborhood the Meadows had become under Laura's enforcement reign, a place where normal life became an enforcement opportunity, and everyone was afraid to step out of line or be seen helping someone who was already targeted. Aaron arrived with his notary kit and took photos of the mailbox, the violation notices, and the handbook pages. He said, "Now write down everything that happened with the tow truck, exact words if you can remember them, and I will notarize it." I spent 20 minutes writing out the scene, quoting Laura's lines about the emergency zone and the timing threat, and her radio call that went nowhere. Aaron stamped the statement and signed it. He said, "Keep this in a safe place, because if she tries to escalate, this is your proof that she lied to a contractor and wasted their time." I folded the statement into a plastic sleeve and put it in my work bag. That afternoon, I got a call from an unknown number. I answered. A man's voice said, "This is Michael Orton. I am an attorney representing the Meadows Property Owners Association, and I need to speak with you about outstanding compliance issues." My stomach dropped. I said, "I am disputing those issues, and I have requested a hearing." He said, "The hearing process does not apply when there is a pattern of willful non-compliance and obstruction." I said, "I have not obstructed anything. I cleared my property, and the fines are not valid." He said, "The board has documented multiple refusals and interference with authorized contractors." I said, "That contractor left because there was no legal basis for the tow." He paused. Then he said, "I am sending you a demand letter. You have 5 business days to pay the outstanding balance, or the association will file a lien and pursue collections." The demand letter arrived by certified mail the next day. It was 3 pages of dense legal language, full of terms like breach of covenant and material non-compliance. The total balance was now $600, which included the original $250, the $50 late fee, a $100 hearing avoidance fee, and $200 in administrative costs. The letter said the board had voted to accelerate enforcement due to my obstruction, and that failure to pay would result in a recorded lien and referral to a collections agency. At the bottom was a signature block for Michael Orton, but no bar number and no law firm address, just a P.O. box in Tracy. I called Aaron. I said, "They sent me a fake attorney letter." He said, "How do you know it is fake?" I said, "No bar number, no firm address, and the language is copy-pasted from a template." He said, "File a complaint with the state bar and send them a cease and desist." I said, "I do not have time for that. They are trying to force me into paying before I can challenge it." He said, "Then you need to go on the offensive. Demand the meeting minutes and the vote records, because if they did not vote on this, the whole thing is fraud." I drafted an email to the management company and CC'd the board email address listed on the HOA website. I wrote, "I am formally requesting copies of all board meeting minutes for the past 6 months, including any votes or motions related to enforcement actions against my property. I am also requesting a hearing under the association bylaws to dispute the fines issued on January 7th and January 9th. I attached photos of the handbook sections showing no 12-hour snow removal deadline and no prohibition on ice melt storage. I hit send and waited. 2 hours later, My garage gate stopped working. I drove up to the entrance and swiped my access card. The reader blinked red. I tried again. Still red. I called the gate company. The automated system said my account was flagged for non-payment. I said, I pay my HO dues every month. This is a mistake. The system said, please contact your property manager to resolve the issue. I called the management company and got the recording again. I left another message, this time angrier. Then I parked on the street and walked to my front door, dragging my work bag through the slush. The next morning, Laura was waiting by my mailbox when I came out to leave for work. She had a clipboard and a tape measure. She said, I need to inspect your snow removal compliance. I said, you are not coming on my property without notice. She said, I have authority under Section 12 to inspect common area adjacencies, and your curb is a common area. I said, the curb is city property. She ignored me and stretched the tape measure from the curb to the edge of the plowed snow ridge. She wrote something on the clipboard. She said, 14 inches of encroachment, that is a separate violation. I said, the city plow pushed that snow there, I did not put it there. She said, I do not care what the weather did, I care what the rule says. I pulled out my phone and started recording. She looked up and said, you cannot record me without consent. I said, I am on my own property, and you are conducting official business, so yes, I can. She stood up and stepped closer. She said, you are creating a hostile environment, and I will add that to the report. I said, good, add everything, because I want a record of this. She turned and walked back to her SUV. Before she got in, she looked over her shoulder and said, you are going to regret this. I kept recording until she drove away. That afternoon, the gate company called me back. A real person this time. She said, your access was suspended by a request from the property manager. Do you want to dispute it? I said, yes. And I want it restored immediately. She said, I will file the dispute, but it takes 3 business days to process. I said, I need access now, I live here. She said, you can get a temporary code if the manager approves it. I said, the manager is not answering. She said, then you will have to wait. I hung up and called Aaron. I said, they locked me out of my own neighborhood. He said, that is illegal, file a police report. I said, the police are not going to care about an HOA gate. He said, file it anyway, because it creates a record, and if this goes to court, you need to show a pattern. I drove to the police station and filed a report for illegal lockout and harassment. The officer took my statement and said, this is a civil matter, we cannot force them to restore your access, but the report is on file if you need it later. I asked if he could call the management company and explain that locking residents out is not legal. He said, I can try, but they will probably tell me it is an HOA issue. He made the call. I heard him say, this is Officer Ramirez with Pleasanton PD. I have a resident here who says his gate access was suspended without notice. Can you explain that? He listened for a minute, then said, understood, but you need to provide due process and notice before you restrict access. He hung up. He said, they claim you have unpaid fines and that the suspension is temporary pending resolution. I said, the fines are fraudulent. He said, then you need to take that up with a lawyer or a judge. We cannot mediate HOA disputes. I left the station and sat in the car, trying to figure out my next move. I had to pick up my sister in 2 hours, and the roads were already slick again. I could not afford to keep missing work or burning gas driving around the gate. I called a locksmith and asked if he could program a universal gate remote. He said, "Not legally. Those systems are encrypted." I asked if he could bypass the reader. He said, "That is tampering, and I could get arrested." I thanked him and hung up. That night I got an email from the management company. It said, "Your hearing request has been received and scheduled for January 24th at 7 p.m. in the clubhouse meeting room. You will have 10 minutes to present your case. The board will vote on the matter at the end of the session. Attendance is mandatory. Failure to attend will result in automatic upholding of all fines and additional penalties." I read it 3 times. The 24th was 2 weeks away. I had 5 business days to pay the demand letter balance, or they would file a lien. The math did not work. They were setting me up to default before I could even get to the hearing. I forwarded the email to Aaron with a note, "They are trying to run out the clock." He replied, "Respond in writing that you are disputing the timeline and requesting an emergency hearing before the lien deadline." Cite California Civil Code Section 5855. I Googled the code. It said HOAs had to provide pre-lien notice and a hearing before recording a lien, and that homeowners had the right to dispute charges during that process. I wrote a reply email stating that I was exercising my right to a pre-lien hearing and that any lien filed before the January 24th meeting would be void. I sent it and CC'd the attorney address from the demand letter. The next morning I woke to a loud banging on my front door. I looked through the peephole and saw a man in a reflective vest holding a tablet. I opened the door. He said, "I am here to install a boot on your vehicle for unpaid association fees." I said, "You are not touching my car." He said, "I have a work order from the property manager." I said, "Show me." He turned the tablet around. The work order had my address and a note that said, "Resident has failed to comply with payment demand. Vehicle immobilization authorized under emergency enforcement powers." I said, "There is no such thing as emergency enforcement powers, and if you put a clamp on my car, I will call the police." He hesitated. I pulled out my phone and dialed 911. He said, "Look, man, I am just doing my job." I said, "Your job does not include illegal repossession." He backed away and said, "I will tell them you refused." He got in his truck and left. I called Aaron immediately. I said, "They just tried to clamp my car." He said, "That is insane. Did you get it on video?" I said, "No, but I have the 911 call log." He said, "You need to file an injunction, because they are going to keep escalating until you pay or move." I said, "I do not have money for a lawyer." He said, "You do not need one. You can file a motion yourself. I will help you draft it." We spent the next hour writing a request for a temporary restraining order against the HOA and Laura Young personally, citing harassment, illegal fines, and attempted vehicle seizure. I filed it at the county courthouse that afternoon and paid the filing fee with my last bit of credit card room. The hearing for the restraining order was set for January 22nd, 2 days before the HOA meeting. I felt a small surge of hope. If I could get the restraining order, it would freeze all enforcement actions and force them to prove their case in front of a judge. But I also knew Laura was not going to stop. She had built her entire role around enforcement, and backing down would mean admitting she had overstepped. I just had to hold on for 2 more weeks. The next few days were quiet. No new notices, no gate drama, no surprise visits. I used the time to pull together every piece of evidence I had: the violation notices, the demand letter, the tow truck witness statement, the handbook pages, the email exchanges, the police report, and the screenshots of the fake attorney signature. Aaron helped me organize it into a binder with tabs and a table of contents. He said, "This is better than half the cases I have seen. You have a solid pattern of fraud and harassment." I said, "I just hope the judge sees it that way." On January 18th, I got a call from a blocked number. I answered. A woman's voice said, "This is Rebecca Marsh. I am the property manager for the Meadows, and I need to clarify some misunderstandings." I said, "The only misunderstanding is that your board is issuing fines without authority." She said, "The board has full authority under the CC&Rs, and your refusal to pay is creating a liability for the association." I said, "I am not refusing to pay legitimate fines. I am refusing to pay fraudulent ones." She said, "The attorney has reviewed your case and confirmed that the fines are valid." I said, "Your attorney is not a real attorney. There is no bar number on his letters." She paused. Then she said, "I will have to get back to you on that." She hung up. If you are enjoying this HOA nightmare, hit the like button and subscribe, because this story is about to get even messier. 2 hours later, I got an email from Rebecca. It said, "After reviewing your concerns, the board has agreed to waive the administrative fees and reduce the total balance to $400 as a one-time courtesy. Payment must be received by January 22nd to avoid lien filing." I read it twice. They were offering a discount, which meant they knew they were in trouble. I replied, "I am not paying any amount until the hearing on January 24th. If you file a lien before that date, I will add it to the evidence packet for the restraining order hearing." I hit send and felt a grim satisfaction. On January 20th, I got a text from an unknown number. It said, "This is Laura. I know you are planning to make a scene at the hearing, but I want you to understand that the board has the votes and the authority to uphold every fine and add more if you continue to obstruct. I suggest you settle this quietly before it gets worse for you." I took a screenshot and forwarded it to Aaron. He said that is witness intimidation. Add it to the binder. I replied to Laura, "Any further contact from you will be considered harassment and reported to the court." She did not respond. The restraining order hearing was on a Thursday morning in a small courtroom in downtown Pleasanton. I arrived early with my binder and my evidence folder. Laura was not there, but Rebecca, the property manager, was, along with a man in a cheap suit who introduced himself as Michael Orton. I almost laughed. The fake attorney was real enough to show up in person, but he still looked like someone who had bought his legal education from a website. The judge, a middle-aged woman with reading glasses on a chain, called the case. She said, "This is a request for a temporary restraining order against the Meadows Property Owners Association and Laura Young, who is representing the respondents." Michael stood up. He said, "I am, Your Honor." The judge said, "Are you listed with the State Bar?" He said, "I am a paralegal consultant." The judge said, "Then you are not an attorney, and you cannot represent anyone in this court. Sit down." Rebecca stood up. She said, "Your Honor, I am the property manager and I can speak for the association." The judge said, "Fine, proceed." I stood up and presented my binder. I walked the judge through the fake tow threat, the invalid fines, the gate lockout, the tire clamp attempt, and the fake attorney letters. The judge read the demand letter and looked at Michael. She said, "Did you sign this letter claiming to be an attorney?" He said, I signed it as a consultant on behalf of the association. The judge said, this letter identifies you as an attorney representing the association, which is unauthorized practice of law. You could face criminal charges. Michael turned pale. Rebecca said, Your Honor, we were not aware of the misrepresentation, and we will be severing our relationship with Mr. Orton immediately. The judge said, You should have been aware, and this court is granting the temporary restraining order. The association is prohibited from filing any liens, suspending any access, or issuing any new fines against the petitioner until the hearing on January 24th. You are also ordered to restore his gate access within 24 hours. I felt a wave of relief so strong, I almost sat down wrong. The judge handed me the signed order and said, If they violate this, come back, and we will hold them in contempt. I thanked her and walked out. Michael and Rebecca did not look at me. I got in my car and called Aaron. I said, We won. He said no. You won round 1. Now you have to finish it. That afternoon my gate access was restored. I tested it 3 times just to be sure. The next morning I got an email from Rebecca. It said, The board has reviewed the court order and will comply with all provisions. The hearing scheduled for January 24th will proceed as planned. Please confirm your attendance. I replied, I will be there. I spent the weekend preparing my presentation. Aaron helped me rehearse. He said, Keep it factual, show the documents, and let them dig their own hole. Do not get emotional. I said, I will try. On the morning of January 24th, it snowed again, a light dusting that turned the streets into a slick mess. I left early to make sure I got to the clubhouse on time. When I pulled into the parking lot, I saw Laura's SUV and 2 other board member vehicles. I grabbed my binder and walked inside. The meeting room was small, with a folding table at the front and rows of plastic chairs. Laura sat at the table with 2 other board members, a man in his 60s and a woman in her 50s. Rebecca sat off to the side with a laptop. There were about a dozen other residents in the chairs, including the couple from across the street who had watched me shovel. Laura called the meeting to order. She said, We are here to address compliance violations filed against the property at 217 Meadow Lane. The homeowner has requested a hearing. We will hear his presentation, then the board will vote. You have 10 minutes. I stood up and walked to the front. I said, I am here to dispute 3 violation notices issued between January 7th and January 9th. I opened the binder and showed the first notice. I said, This notice claims I failed to clear snow from the curb within 12 hours. The handbook does not specify a 12-hour deadline, and the curb is city property, not HOA property. I showed the handbook page. I said Section 4 only requires homeowners to clear sidewalks and driveways. The board does not have authority to enforce city code. Laura interrupted. She said, The board has discretion to interpret the rules based on safety concerns. I said, The board does not have discretion to invent new rules without a vote. I showed the second notice. I said, This notice fines me for storing ice melt in an open container. The handbook Section 9 does not mention ice melt. It only covers trash cans, grills, and recreational equipment. Laura said, The rule is intended to cover all unsightly storage. I said, Then the board needs to amend the rule through a proper vote and notice process. You cannot retroactively fine someone for something that is not written. I showed the third notice, the one about snow encroachment. I said, This notice claims I created a 14-inch encroachment on the curb. The snow was pushed there by the city plow. I did not place it there. Laura said, "You are responsible for clearing it." I said, "The city plow came through at 4 in the morning after I had already cleared the driveway. You measured it at 7 a.m. and issued the fine. That is not reasonable notice or a reasonable standard." Laura's face went red. She said, "You are wasting everyone's time with semantics." I said no. I am pointing out that you are issuing fines without legal authority. I pulled out the fake attorney letter. I said, "This letter was sent to me by someone claiming to be an attorney representing the HOA. A judge confirmed this week that it was unauthorized practice of law, and the board has now severed ties with that person. I am including this as evidence that the enforcement process has been conducted in bad faith." Rebecca stood up. She said, "That is not relevant to the violations." I said, "It is absolutely relevant, because it shows a pattern of intimidation and fraud." I pulled out the police report for the gate lockout. I said, "The board suspended my gate access without notice or due process. A judge ordered it restored." I pulled out the witness statement from the tow truck incident. I said, "The board sent a tow truck to my property claiming I was parked in a winter emergency zone that does not exist. The driver refused to hook my car because there was no legal basis." I pulled out the screenshot of Laura's intimidation text. I said, "The board coordinator sent me a threatening message 2 days before this hearing, trying to pressure me into settling." The room was silent. The 2 other board members were staring at Laura. The man in his 60s said, "I was not aware of half of this." Laura said, "Those are taken out of context." I said, "I have recordings, emails, and court orders. Nothing is out of context." The woman board member said, "I think we need to table this and consult with legal counsel." Laura said, "We do not need legal counsel. We have the authority to vote right now." The man said, "No. We need to review this properly." Laura said, "You are letting him bully the board." I said, "I have one more thing." I pulled out a printed transcript. I said, "This is a transcript of a phone call between Laura and the tow company on January 7th. I obtained it through a public records request, because the tow company is a city contractor and their dispatch logs are public." I read from the transcript. Laura Young called at 6:43 a.m. and requested an emergency tow for a vehicle parked in violation of HOA rules. The dispatcher asked for the violation code and posted signage. Laura said, "I do not have that right now, but I have the authority to authorize the tow." The dispatcher said, "We cannot dispatch without documentation." Laura said, "Then I will call someone else." I looked up at the board. I said, "She tried to have my car towed without any legal basis, and when the company refused, she tried to intimidate them into doing it anyway." Laura stood up. She said, "That is a lie." I said, "It is a public record, and I will submit it to the court if you force this to trial." The man board member said, "Laura, did you make that call?" Laura said, "I made a call to inquire about tow services. I did not authorize anything." I said, "The transcript says otherwise." The woman board member said, "I move to dismiss all 3 violations and refund any fees paid." The man said, "I second." Laura said, "You cannot do that without a full board vote." The woman said, "We are 3 board members. That is a quorum." Laura said, "You are undermining my authority." The man said, "Your authority comes from this board, and we are voting now. All in favor?" He and the woman raised their hands. Laura did not. The woman said, "Motion passes. The violations are dismissed." Rebecca said, "I will process the refunds and update the records." Laura stood up and walked out of the room without another word. The residents in the chairs started murmuring. The couple from across the street gave me a thumbs up. I sat down and felt the tension drain out of my shoulders. Aaron had been right. I just had to let them dig their own hole. After the meeting, the man board member came over and shook my hand. He said, "I apologize for what you went through. I was not involved in any of this, and I am going to make sure it does not happen to anyone else." I said, "I appreciate that." He said, "Between you and me, Laura has been doing this for 2 years. And half the neighborhood is afraid to challenge her. You just gave everyone permission to push back." The woman board member said, "We are going to call an election to replace her position, and we are going to review every fine she has issued." I said, "Good, because I guarantee I am not the only one." I walked out to the parking lot and called my sister. I said, "It is over." She said, "Did you win?" I said, "They dismissed everything and voted to refund the fees." She said, "I am proud of you." I said, "I am just glad I do not have to fight anymore." She said, "You should celebrate." I said, "I am going to sleep for 12 hours. But the story did not end there. 2 days later, I got an email from Rebecca. It said, "The board has reviewed Laura Young's records and identified multiple cases of improper fines, unauthorized contractor agreements, and procedural violations. A special election has been called for February 10th to fill the fines and enforcement coordinator position. Laura has resigned effective immediately. The association is offering refunds to all homeowners who were fined under her tenure. Please submit a request if you wish to receive a refund." I forwarded the email to Aaron. He replied, "You did not just win your case, you burned down the whole system. Congrats." A week later, I got a check in the mail for $400, a full refund of every fine I had paid since moving in. I also got a letter from the new interim board. It said, "The Meadows Property Owners Association is committed to fair and transparent enforcement. We apologize for the actions of the prior coordinator and are implementing new procedures to prevent abuse. If you have concerns about past enforcement actions, please contact the management company." I filed the letter with the rest of my evidence binder and put it on a shelf in the garage. The neighborhood changed after that. People started saying hi when I shoveled the driveway. The couple across the street invited me over for coffee and told me they had been fined 3 times for minor infractions and had just paid them to avoid trouble. They were filing for refunds. A guy 2 doors down said Laura had threatened to fine him for a broken porch light during a power outage, and he had been too scared to fight it. He was filing too. By the end of February, the association had refunded over $12,000 to 23 homeowners. Laura never came back to the neighborhood. I heard from Rebecca that she had moved to another development in Livermore and was trying to get on the board there. I felt a little sorry for those residents, but I also knew they would figure it out eventually. People like Laura only have power when nobody pushes back. Once someone does, the whole thing collapses. I sold the house in April and moved to a place closer to my sister, a small neighborhood with no HOA and no covenants. The new owner sent me a message a month after closing. He said, "I just got a welcome packet from the HOA, and they mentioned your case as an example of how they reformed their enforcement process. You are kind of a legend here." I replied, "Tell them to stay vigilant, because it only takes one bad board member to start the cycle again." He said he would. Looking back, the whole experience taught me that the rules only work if people follow them, and people only follow them if someone holds them accountable. Laura thought she could invent violations and intimidate people into paying, because that is what had worked for 2 years. But the moment someone called her bluff, the entire operation fell apart. The fake attorney withdrew mid-crisis. The board panicked because they had to answer homeowners with no cover, and the minutes recorded the reversal and the reason. Laura got corrected by the HOA attorney in plain language, and a board election challenge flipped the power dynamic. The funny karma moment came when Laura insisted the tow was authorized and the tow driver hesitated, because even he knew it was not real. If you are dealing with an HOA that is overstepping, document everything, get witnesses, and do not be afraid to push back. The law is on your side if you follow the process, and if they try to intimidate you, remember that intimidation only works if you let it. I did not let it, and I got my life back. Thanks for watching, and thanks for all the support.